The next item of business is a motion to approve a statutory rule. I will ask the Clerk to read the motion.
That the Coronavirus Act 2020, extension of provisions relating to live links for courts and tribunals, No. 2 Order, Northern Ireland 2023, be approved.
And I call the Minister of Justice to move the motion. Thank you. The Business Committee has agreed that there should be no time limit on this debate. I call the Minister to open the debate on the motion.
Thank you, Mr Deputy Speaker. And I'm seeking in today's debate for the Assembly's approval for the Coronavirus Act 2020, extension of provisions relating to live links for courts and tribunals, No. 2 Order, Northern Ireland 2023, SR 2023 No. 138. The motion is that this order would be approved. 2 years ago, I moved a similar motion for approval on the 1st of March 2022. On that day, I did not anticipate we would have no opportunity in the intervening period to bring forward alternative legislation within an Assembly bill. It remains my intention, and indeed my strong preference, to make new primary provision for the use of live links for this jurisdiction through the Assembly, and I plan to do so using the first bill my department plans to introduce to the Assembly. The Modernisation of Justice Bill will be introduced in the coming months, and with support from this Assembly, we would anticipate alternative live links provisions will be enforced by 2026. In the interim, we are compelled to rely on these provisions as a temporary measure. Article 2 of this order extends the provisions allowing courts and statutory tribunals in Northern Ireland to receive evidence, wholly or in part, using audio or video conferencing systems, but primarily video. These systems are commonly referred to as live links. They facilitate the wider provision of remote evidence, as well as disposing of mentions or hearings which can include matters such as first appearances and bail applications. This extension, covering the period from September 2023 to March 2024, was to allow us to maintain access to provisions that have proved to be an essential element of the toolkit for addressing the backlog of cases that accrued during the pandemic. I fully understand why some members are concerned about it continuing to rely on the Coronavirus Act, and I agree that that is far from ideal. However, I have to balance this against the needs of court users, including victims of crime. The current model of live link provisions has particular importance for the criminal courts. The most recent update on criminal court recovery in January 2024, based on management information on the number of defendants actively in the court system, shows that despite considerable efforts, there are approximately 64% more defendants within the Crown Court and approximately 43% more defendants in the Magistrates' Courts, both adult and youth, than there were on the 1st of March 2020. In the absence of these provisions, we would have to default to the pre-existing legislation, which is much more restrictive, both in terms of category of witness and range of hearings to which it can be applied. More to the point, other than witnesses who meet the existing test to avail of special measures, the pre-existing provisions within the criminal courts mainly concern the facility either for a witness other than the defendant to appear remotely, or for the defendant himself or herself to appear remotely. The latter requires the defendant to consent. For witnesses other than the defendant, the available test is less generous to the victim or to witnesses. It focuses on the efficient administration of justice and allows the defendant to challenge the use of live links, including on grounds such as their availability, the importance of their evidence, and the defendant considers that the live link would inhibit defence from effectively testing that evidence. This would be a backward step in terms of meeting the needs of victims and witnesses. During the last mandate, all members of the Executive had expressed support not only for a 6-month extension in March 2022, but also for the proposed additional extensions identified as required to allow time for a public consultation to take place and new provisions to be developed for inclusion within an Assembly bill. The Justice Committee had also signalled its support. Just to give a bit of history, Mr Deputy Speaker, on these provisions, as far back as the 2015 programme for government, the plan has been to redesign and optimise public service delivery models. Events in 2020 simply required us to accelerate the digital modernisation programme underway within the Northern Ireland Courts and Tribunal Service and invest in technology needed to maintain the throughput of cases. It would be wasteful, therefore, not to optimise the investment already made in this technology, especially where it can help avoid unnecessary delay in disposing of matters before the court, which the judiciary consider is suitable for a live link. At the height of the pandemic, when footfall was restricted, the number of connections averaged over 70,000 per month. Today, there are on average approximately 30,000 connections per month. However, this is still substantially more than was the case before 2020, when there would have been fewer than 100 connections per month. I'm therefore extremely reluctant to lose the availability of this enhanced digital court environment, which supports the needs of court users and is based on the judiciary determining what is in the best interest of justice, rather than being dependent on the defendant's consent. We have conducted a series of engagement exercises since November 2021, and the responses on each occasion demonstrated overwhelming support for extending these provisions while the justice system is still recovering. On each occasion that we have considered making an extension, a review has been conducted of the equality, data and rural impact, and our assessment has been updated where appropriate. There's also been strong support for new primary provision to be made locally for the use of live links in the future. The benefits to be gained from the wider use of live links within the justice system are recognised across these islands. Greater use of live video conferencing or TV links can reduce distress for some participants. Remote attendance can allow professional witnesses, such as police officers, social workers or medical experts, to continue working while they wait to be called to give their evidence. It can also provide a saving in legal aid costs, substantially reduce our carbon footprint and assist in speeding up our justice system. I hope the Assembly, like me, will see this order as a critical component of justice recovery, as well as modernisation of the justice system. Little has changed to undermine the rationale for the approach agreed previously with the Executive and the Justice Committee, save that we are regrettably 2 years later than I intended in progressing the Assembly bill. I commend the approval. I will indeed.
The Minister brings an order which itself expires in 10 or 11 days' time. She indicates that she anticipates in a longer term primary legislation. Does that mean that in a few weeks we'll be subject to another extension under the Coronavirus Act?
Yes, Mr Deputy Speaker, it does, and I mentioned that at the beginning of my speech, that this is the first of a series of extensions that we will need in order to maintain efficacy in the system while we bring forward legislation. Mr Deputy Speaker, on that note, I want to commend the approval of this order to the Assembly. Thank you.
Thank the Minister for opening the debate, and I call Joanne Bunting, the Chair of the Justice Committee.
Thank you, Mr Deputy Speaker. Initially, I rise in my capacity as Chairperson of the Committee for Justice and declare that I have an immediate family member who works in the legal profession. As the Minister has already outlined, the statutory rule before us extends the provisions in the Coronavirus Act 2020 which allow courts and statutory tribunals to receive evidence through audio or video links beyond this month when they are set to expire. The Committee initially considered this rule at its second meeting, which was held on the 22nd of February. Members noted that this was the latest in a sequence of statutory rules extending these provisions. The Committee further noted that while the Examiner of Statutory Rules had raised no concerns regarding the technical aspect of the rule, her first report had drawn attention to a number of statutory rules subject to the confirmatory resolution procedure, including this rule and those that preceded it. The Examiner stated that the confirmatory resolution procedure is used for more significant exercises of delegated powers. Positive action by the Assembly is required for the subject statutory rule to continue in force. The use of successive statutory rules has had the effect of ensuring that, where an individual rule ceased to have effect, its provisions prevailed in the statutory rule that followed it. Members also noted that towards the end of the last mandate, the predecessor committee had considered the proposal for one of the earlier rules to extend similar provisions. At that time, the committee was advised that the extension was part of a two-staged legislative approach, whereby the provisions would initially be extended by subordinate legislation and an Assembly bill would then be developed to make permanent provision for the use of audio and video links. The current committee agreed to ask the Department for its views on whether the continuous use of the powers in the Coronavirus Act 2020 is proportionate and appropriate in the post-COVID environment. The committee also requested an update on the Department's plans to make permanent provision for the use of audio and video links. The Department's response was subsequently considered at the meeting of the 29th of February, when the committee was advised that the Minister was satisfied that there remained a clear role for the continued use of the provisions to tackle the backlog of cases that accrued during and since the pandemic, and may take excuse me, until 2028 to clear without extra resources. The Department also advised that it was the Minister's intention to include provisions for the wider use of live links within the first bill the Department plans to introduce, which is anticipated before the summer recess. The Committee was assured that reliance on the powers in the Coronavirus Act 2020 is therefore an interim arrangement. Mr Deputy Speaker, having considered the response from the Department, the Committee agreed that it was content to recommend that the statutory rule be approved by the Assembly. Before I conclude, I want to mention that at its last meeting, the Committee discussed another proposal to further extend these provisions with departmental officials. The officials reiterated that they expect that the permanent provision for live links will indeed be included in the first departmental bill. However, it is unlikely that the necessary provisions will be drafted in time for inclusion in the bill as it is introduced to the Assembly. Instead, they will be brought forward as amendments at consideration stage. I recognise that most committee members are broadly supportive of the principle of the use of live links and agree that they should be a feature of our court system. And while I thank the Department for its candour, nonetheless, bringing provisions forward at consideration stage is far from ideal, as it means that the provisions cannot be included within the Committee's call for evidence, and the Committee will not have the opportunity to undertake proper scrutiny during committee stage of the bill.
I thank the member for giving way, and I'm aware that this was a concern that was raised at the committee. To reassure the committee and indeed the chair and vice chair of the committee on that point, it is our intention in the department to share an early draft of the regulation that we intend to bring through the legislative amendment, and hopefully that will allow the committee then to take evidence on that matter as well. It's simply to do with the finalising of drafting and the resource available that it means it will be delayed beyond the point where the committee would start its consideration. But we hope to be able to share an early draft in order that you can consult on that too.
Thank you, Mr Deputy Speaker, and I'm grateful to the Minister for her clarification and assurances in this regard, which did cause the committee some consternation. No doubt this is a discussion to which we'll return at a later stage, and you'll appreciate, Minister, that I do have some remarks to make upon that in the course of as I continue. In the interim, I support the motion before us today on behalf of the Justice Committee, and now would turn to my remarks in my capacity as an individual MLA. Firstly, I would like to extend my best wishes for a speedy recovery to Mr Long. We served on Castlereagh Borough Council and worked well there together for many years, and I was very sorry to hear of his recent ill health, and I trust the Minister will pass on my good wishes to her husband. Well, on a personal level, I support the principle and the requirement for live links and audio links. My issues are more around process. I remain concerned about the continued extension of emergency powers long after the pandemic, particularly since by their nature they were not rigorously scrutinised. Having been assured that provision would be made in the first bill, some of us were somewhat taken aback to discover that the intention was only to bring forward such provision at consideration stage by way of an amendment, but I'm grateful again to the Minister for her clarification. There are some issues around live links that should be properly scrutinised to better inform guidance and practice, improve consistency of application and use, and consider equality of arms issues. In addition, when one calculates the time frame involved to scrutinise and progress what I anticipate will be a sizable first departmental bill, it is inevitable that yet further extensions of the emergency coronavirus provisions will be required. It does beg the question as to why a smaller standalone bill is not being brought forward, and why, as a result of their inclusion in another sizable bill in a most unusual step, the provisions will not be included in the bill as printed, so as to be included in any calls for evidence, but the Minister has clarified that. I think it is important that we move away from reliance on emergency legislation deriving from the pandemic. Where legitimate and beneficial changes have been found which can be built upon and legislated for properly, we should do so at the earliest opportunity. I have made my point about my preferences, Mr Speaker. Nevertheless, I understand the need and requirement for the live links to continue, and in this circumstance will support the extension. Thank you.
And thank you. I call Deirdre Hargey.
Thank you very much. And again, just to start to echo again my thoughts with Michael, Naomi as well, and it was actually good to see that he was out on Friday, and hope he makes a full recovery. Again, obviously, as was touched on, we discussed this at the Justice Committee last Thursday, and obviously, yes, there was concerns raised in terms of the Coronavirus Act being used, and I suppose asking the Department over the last few weeks to ensure that a permanent mechanism is brought forward. Again, this was raised with the Department at the last few Justice meetings, and they did respond positively to say that legislation would be coming in the next few months. And again, I welcome the Minister's interjection just to say that we would see that in draft form, because I think it will be important with these provisions and to ensure that they are as robust and effective as they can, that we do have that opportunity to scrutinise as early as we can. Again, in the short term, I do believe, like others, that there's no option but to extend the current provisions to allow live links, because they are critical and they must be maintained, albeit they need to be enhanced as well. Because this is allowing our courts and our tribunals to receive audio and video evidence wholly or in part via the live link mechanism. And therefore extending these provisions is essential for victims of crime especially. And this was also echoed at the Justice Committee last Thursday by the Victims of Crime Commissioner Designate. And in their subsequent reports that they have put in on this issue and the consultation that's taken place. We need these provisions in because it does reduce the impact of people, especially those who are most vulnerable. And that is an area that we want to look at as more permanent legislation comes forward. It also importantly allows children to give evidence in a child-friendly and neutral environment. And again, ensuring that access to justice, ensuring that it is child-friendly, is a critical part of the overall system. So we need to make sure that these interim measures continue in that vein. And importantly, also meeting the Victims' Charter obligation. Again, we had an in-depth discussion in terms of the role of the Charter, and importantly providing separate waiting areas from defendants is critical to that Charter, and again live links can play a role in that regard. It is essential, as I say, in the short term that the provision continues, but we do need more robust primary provision, and again I just welcome the Minister's words on that today. We need to make sure that those permanent provisions have enhanced participatory rights, particularly for victims, that there's greater planning and coordination around them, that they are rights-based and that we're embedding a culture of rights within the justice system more widely. And importantly, that we use this opportunity over the coming months as we start to look at legislation that will come forward and scrutinise it, that we're looking at effective learning and best practice from elsewhere across these islands and beyond. So again, I just want to welcome the fact that we're moving on this today to give that certainty to the service, and importantly for those that utilise live links. Again, I just want to thank that we will get early sight of the drafting so that we can scrutinise it. And importantly, we all want to ensure that we have more effective measures that actually enhances the role of these for victims, defendants and for others, and to ensure that we speed up our justice system overall. So again, thanks very much for just tabling this today.
Thank you. I call Stuart Dixon.
Thank you, Deputy Speaker, and I rise to thank the Minister for the work which she has done in bringing this forward, and the very clear explanation which she has given to the House in order to assist us in the delivery of these regulations today. No intention of going over issues which have been raised in support of this, both by the Chair and Vice Chair of the Committee, but I think it does bear consideration that when we had the Victims of Crime Commissioner Designate with us at the Committee this week, she spoke passionately and with great example of the work that live links can deliver, particularly for victims of crime. I think that it is important that we allow this legislation to go forward today. Imperfect though it is, and the vehicle is not one which I don't think any of us in this House are particularly comfortable with. So I particularly welcome the Minister's statement that she intends to bring forward permanent legislation in a larger bill which will cover this, particularly the area of concern which was raised at the Justice Committee last week, where the Minister has again made a very clear statement to the House today saying that an early draft will be provided to the Committee, and that should allay any concerns that the Committee has to allow us to consult on the legislation. The Minister also touched on one point which I think is vitally important, and that is judicial oversight of the use of live links is vitally important. So Deputy Speaker, with those few words said in respect of this, I am pleased that we are in a position today to support this regulation and welcome the fact that a pathway has been clearly set out to take us into the future and for the delivery of live links and all of the comments that people have said in the Chamber. Thank you.
Thank you. All members listed to speak have done so. I now call on the Justice Minister to conclude and wind up the debate.
Thank you, Mr Deputy Speaker, and thank you to those members who participated in the debate. And I want to welcome and thank members for their contributions. I think the near universal consensus of the Assembly is that we would prefer we were able to do this by primary legislation, but we recognise that it is important that we're able to maintain these provisions while that legislation is able to be developed. There are just a number of issues, I guess, that I do want to touch on, because the question, I think, was asked particularly by the Chair about why this couldn't be done more quickly and have a standalone live links bill. Unfortunately, unlike the Department for Communities, which has now ceased using CVA provisions to facilitate hybrid council meetings and is going to do that through regulation, we have no other primary legislation within the justice field that would allow us to bring forward similar secondary legislation. So this has to be done by primary legislation and therefore will take considerable time. We also need to accommodate that alongside other legislative requirements that face the department. I would prefer a new primary provision for live links was in place sooner rather than later, but the reality is we have another shortened mandate in which to push through legislation, plus a backlog of legislative changes from the last mandate that still need to be progressed. I've therefore approved a legislative programme for my department that will allow us to progress those outstanding legislative changes through a mixed content justice bill, as well as deliver on my legislative priorities of a sentencing bill and a hate crime bill. I'd much prefer to have a series of smaller thematic bills, but the reality is we just don't have time to do that within this mandate, and I wish it were otherwise, but that is where we are. I also want to make sure the legislation that we bring forward is robust and future-proofed and takes account of learning from the past few years. It's not simply a question of replicating what was in the Coronavirus Act and turning that into primary legislation, so it is a more complex piece of work. We have, for example, consulted publicly, had significant engagement with stakeholders and kept abreast of developments in other jurisdictions, as the Vice-Chair mentioned. And we're aiming to share the draft clauses with the Justice Committee in time for them to be considered during committee stage of the Justice Bill, and I will write to the Committee well in advance to set out the policy approach that we're adopting. I reiterate that we want there to be proper scrutiny of this legislation. We want the opportunity to engage with the sector, and we want what we produce to be robust. But in the interim, it is important that we have this extension and that we get future extensions that will guide us through to the point where the new legislation is in place. To lose live links would not only set back the recovery of the justice system and slow down the issues of delivery of justice, but it would also represent quite an impediment to many of the more vulnerable victims and witnesses who participate within the justice system, and often would place, for example, in certain categories of domestic abuse cases, would place the power back in the defendant's hands as to whether or not remote access to the court was allowed. And I think that that would be a regressive step given how far we have proceeded over recent years in that regard. I hope that I have answered any questions or queries that members have and have satisfied them on the importance of this going forward for approval today. Members are aware that we often hear victims and witnesses comment that the criminal justice system doesn't focus or work well for them. I just want to reassure members that in this occasion, this is particularly targeted at those victims and witnesses to make their journey through the justice system as stress-free as it can be, and to make a positive difference not only to them, but in terms of helping us address the challenges presented to the justice system over recent years, and also in contributing to the modernisation of our courts and a smart use of our resources that we have available. So I thank members for their support. Thank you.
Thank you, Minister. The question is that the Coronavirus Act 2020, extension of provisions relating to live links for courts and tribunals, number 2, Order Northern Ireland 2023, be approved. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it.